Good afternoon, everyone, and welcome to this evening's event. It's time for a National Human Rights Act, hosted in collaboration between the Queensland Council for Civil Liberties, New South Wales Council for Civil Liberties, Liberty Victoria, and Civil Liberties Australia. My name is Angus Murray, and I'm a Vice President of the Queensland Council for Civil Liberties, and it is a pleasure to be able to host such an important topic of an event at such a critical time. If I could begin firstly by acknowledging our First Nations people, their elders past, present and emerging, their culture, history and lessons we continue to learn from. This evening we will have two sets of speakers. Firstly, Mr. Scott McDougall, the Queensland Human Rights Commissioner, and secondly, a presentation from our colleagues at Civil Liberties Australia on the path to a Human Rights Act at a federal level. Introducing firstly the Queensland Council of Civil Liberties, we, like each of the Civil Liberties associations collaborating to put this event on this evening, are a volunteer organisation that works to protect the human rights and civil liberties of Queenslanders. Since 1966, we've campaigned for law reform on everything from privacy to protest law, and promoted human rights in the media and hosted a range of educational events, such as this. Human rights are a fundamental freedom and is inherent to all individuals, regardless of their nationality, ethnicity, religion, or any other status. They encompass a broad range of rights, including civil, political, economic, social, and cultural rights. Human rights are universal, meaning they apply equally to everyone, everywhere, and they are protected by international law. These rights include the right to life, privacy, liberty and security, freedom from discrimination, the right to education, healthcare, and a standard of living adequate for well-being. Human rights provide the foundation for dignity, equality, and justice in society, serving as a cornerstone for peaceful coexistence and development. In Queensland, we had the Queensland Human Rights Act 2019 introduced as a result of many years of collective activism from the Queensland community. Queensland is the third Australian state to have passed human rights legislation, following the Australian Capital Territory with its 2004 Human Rights Act and the Victorian Charter on Human Rights and Responsibilities in 2006. The Queensland Human Rights Act protects a number of human rights drawn from international instruments, such as the International Covenant on Civil and Political Rights, the International Covenant on Social, Economic and Cultural Rights, and the Universal Declaration of Human Rights. Importantly, at a federal level, our Constitution only contains limited express human rights as protected in the text of our Constitution, and they are the right to vote, the right for the Commonwealth not to acquire property other than on just terms, the right to a trial by jury, the freedom of interstate trade, a freedom of religion, and a right to trial by jury. We have some limited implied rights in the Constitution, but we are the last Western democratic country to implement a explicit human rights framework at a federal level. It has been argued for many years that Australian human rights need to be codified into law, and this has been a long-standing position of advocacy of a number of the organisations, in fact all the organisations that are collaborating to put this event on this evening. An important step towards a Federal Human Rights Act occurred in March 2023, when the Attorney General referred the Human Rights Parliamentary Scrutiny Act to the Parliamentary Committee on Human Rights for a review, including a question on whether Australia should develop a Human Rights Act at a federal level. There has yet to be an outcome to that review, and with an election looming on the weekend, it seems an opportune time to have a conversation about what a Human Rights Act would mean at a federal level. This event will be framed, as I said, in two parts. Firstly, Scott McDougall, as Queensland's Human Rights Commissioner, will outline the situation in Queensland, and then our friends at Civil Liberties Australia will discuss what the pathway to a Federal Human Rights Act has been. There will be opportunities for questions after each speaker. And if I can firstly introduce Scott to this event. Scott is Queensland's Human Rights Commissioner. He has a broad practice prior to his appointment as Queensland's Human Rights Commissioner, including being the Anti-Discrimination Commissioner in Queensland since October 2018. He's been admitted to legal practice since 1993 and has advocated on behalf of communities and conducted litigation, particularly in the areas of discrimination, native title, and criminal law, for a number of years. Scott is a particularly important and powerful voice in this space, and it's a pleasure to have you here with us tonight, Scott. Thank you.
Thank you very much, Angus, and thank you for the host. So you'll see on my slide, so I've got Queensland Council of Civil Liberties. I didn't realise it was being co-hosted by the other organisations as well. And I guess I'd just like to start by, I will acknowledge the traditional owners in a moment, but by acknowledging the important work that each of these civil liberty organisations do and have done in Queensland's case, as Angus said, since the 60s. And I think one of the most impressive things about an organisation like QCCL is that, to my knowledge, they've never sought or received or taken or accepted a single cent of government funding. And I think their independence and integrity are unquestioned as a result of that, and they can always be relied upon to take a principled position to really important issues that are confronting the community, which obviously have been many and varied over the decades in Queensland especially. So if I could begin by acknowledging the Turrbal people and the Yagara people who are the traditional owners of the country that I'm on this evening, and pay my respects to their elders and emerging leaders. This photo here, you may recognise this gentleman, Shannon Rusker, who has performed a number of welcome to countries at some pretty major events, and takes a pretty entertaining approach to some of them. This photo was taken at an oration that the Commission holds on a biennial basis called the Mabo Oration. I'm just putting in a plug here for anyone who happens to be in Cairns on the 30th of May, because Social Justice Commissioner Katie Kiss will be delivering the next Mabo Oration that evening, something I'm really looking forward to. So tonight I was going to give you a quick background to Queensland's Human Rights Act campaign experience, talk about some of the highs and lows of implementing the Human Rights Act in Queensland, and then finally give, for what it's worth, some of my tips for the national campaign. So in Queensland, some of you may be aware, but the act that we currently have in Queensland was not the result of the first attempt to introduce a Human Rights Act in this jurisdiction. So back in 1959, the member Nicklin introduced a bill that did lapse the following year, but nonetheless, it was an attempt to introduce human rights in a codified way in Queensland. Then, after the Goss government came to power in the 1990s, there was a Electoral and Review Commission established, and one of its recommendations was that a human rights bill be enacted. That was followed up and championed by Attorney General Matt Foley, who was very much in favour of the model of an entrenched constitutional model, which obviously, and I'll talk about the enforcement, and no doubt CLA speakers will be talking about enforcement as well. But an entrenched model is obviously far more enforceable by the courts because they can effectively strike down laws. That attempt by Matt Foley was ultimately unsuccessful, and it wasn't until after toward the end of Campbell Newman's term of government in 2015 that the idea of introducing human rights legislation in Queensland was then next seriously ventilated. And really it was the excesses of the executive at that time of Campbell Newman's government that I think galvanised the community into running what it ended up being a very strong community-based campaign for a Human Rights Act in Queensland. So the catalyst for the campaign in Queensland was in fact Peter Wellington, who was an independent member of Parliament, who in the dying days of the Newman government called for the introduction of human rights protections. As it turned out, after the election, there was a minority Labor government, and Peter Wellington was then appointed as the Speaker of the House, and the letter of agreement that he effectively reached with Labor required Labor to consider the introduction of a Human Rights Act in Queensland. So that was the opportunity that was created, and you'll see in this photo here there were a number of the critical members, including Michael Cope from QCCL, who came together to work constructively on a really strong grassroots campaign for a Human Rights Act. Also in that picture is Amy McVie, who's the now CEO of QCOS, Queensland Council of Social Services, and Professor Susan Harris Rimmer, who recently conducted a independent review of the Human Rights Act, which I'll talk about a little bit later on as well. So I think the important thing to note about the Queensland campaign was that it was very targeted, very strategic, and there was actually, unlike Victoria, which had a very strong champion within Cabinet in the front bench in the form of Rob Hulls, Queensland didn't have that champion. And if I was to point to a champion within the government, I'd probably point to Peter Russo, a backbencher, and perhaps also Jackie Trad, the then Deputy Premier and Treasurer. They were probably the strongest advocates for the Act. But really, it was the campaign that led to the government, the Palaszczuk government, coming up to the next election in November 2017, making an election commitment to introduce a Human Rights Act, which was a massive step for them to take. And there's a whole story behind that, which I don't have the time to go into, but I'm sure Michael will regale you with many stories there. And I guess the other point that I thought was worth making was that we did have, even though the Queensland Law Society, in its submission to Parliament about the whether there should be an act, and then eventually on the human rights bill that was introduced, even though the Queensland Law Society was adopted a position of acknowledging both sides of the argument and weren't firmly supportive of introduction, they nonetheless did allow for their members to engage constructively in it, and they have subsequently been quite supportive of the implementation of the Act. They've established a committee of a human rights committee within the Law Society of members that make important contributions to the policy that the Law Society advocates on in the parliamentary committee hearing process. So in terms of the model that was enacted in Queensland, most of you would probably be aware that parliamentary models of human rights are often described as the dialogue model, as opposed to a constitutional model that I referred to earlier. So they are susceptible to being overridden as in any other ordinary act of Parliament, and laws that are incompatible with human rights cannot be struck down, but the court can make a declaration of incompatibility, which then goes back to Parliament so that Parliament reconsiders the law. And incidentally, so far in Queensland, that the Supreme Court is yet to make such a declaration. The other features of the model are there's no direct cause of action. There's only an indirect cause of action where you can piggyback your human rights argument onto other independent causes. There's no access to damages in Queensland, and what there is a complaint mechanism that is limited to conciliation within my commission, and for unresolved complaints, the commission can publish a report that can include recommendations about the steps that we think the public entity should take to act compatibly with human rights in the future. The other features are that, as Angus mentioned, there were 2 economic, social and cultural rights that were included in Queensland's Act, which were novel, and that was the right to access education and also the right to access health services without discrimination. And I guess we still really haven't seen a full exploration of the scope of those rights, and I think whilst there's been some litigation in Queensland and some jurisprudence emerging, which is very encouraging, we really haven't seen those rights fully explored. And I think perhaps later this year there may be a health case around the decision of the Queensland government to suspend access to puberty blockers for trans children. I think that's a matter where you may well see the right to access health services ventilated, but the education rights are really yet to be explored in any meaningful way. So some of the highs and lows, I guess. So to me, the biggest value, and I think this is something to bear in mind when you are advocating for human rights legislation, the biggest value really is around requiring decision makers to take into consideration reasonably available alternatives when they're exercising their discretion. So I think there really is an opportunity to improve public decision making and accountability. And in the early days of implementation of the Queensland Act, I think one of the clear benefits was there was an uplift in the internal complaint processes of various public entities in Queensland. So there is a requirement before someone can make a complaint to my commission that they first have to lodge a complaint with the public entity directly. And unless there are exceptional circumstances, they have to await a period of time before they can bring a complaint to us if they're not satisfied with the internal complaint process. So this provided an opportunity for public entities to improve their own internal processes. And I have to say that there were some significant improvements made in some agencies. I think also we have seen a slow build of a human rights culture within some public entities. And I guess I would give a shout out to the Department of Housing in Queensland, which really has taken on board the Act in meaningful ways. Have seen some good results with our complaint mechanism, even though there's no direct cause of action in Queensland. As I mentioned, people can make a complaint to us, and even though they don't have a pathway to a tribunal, there's still an opportunity to sit down with a public entity and have that complaint professionally conciliated by our team. And during COVID, we really did see some good results through that complaint mechanism. So, for example, people who were inappropriately housed in hotel quarantine conditions that were just not suitable for, say, families with young children with disability. We were in several cases able to have those families reaccommodated, sometimes in a matter of hours, rather than, having to resort to say judicial review application, which not many people obviously have access to in those circumstances. So it really did demonstrate its value during COVID, at least in terms of hotel quarantine arrangements. We've also had many other successful complaints, but I think the issue of there not being a direct cause of action has impacted on the success rate of those human rights complaints, which are well below the success rate of our Discrimination Act complaints, where there is a right to continue a complaint through to a tribunal. And I think that reflects the lack of bargaining power that a complainant has under the Human Rights Act process. I think another high from the introduction of the Act has been an overall uplift in the literacy of non-lawyer advocates in human rights. So ultimately, if we are going to create a human rights culture, we want everyone to have the language of human rights to be able to make the case, instead of having to rely on lawyers to do all of the advocacy through litigation. I think it's really important that non-lawyer advocates are armed with the language of human rights. And I think we've certainly tailored some of our training modules to those advocates. And I think as our Human Rights Act regime matures, I'd like to see even greater levels of literacy amongst non-lawyer advocates. Some of the low points, you may, for those of you who follow Queensland, would know that the Human Rights Act in Queensland has been overridden on a number of occasions now. I think we're up to 3, and should be 4, but there's no override declaration so far that I've seen on the latest legislation going through. And I guess the Act, to be blunt, has failed to protect particularly overwhelmingly First Nations children who have been languishing in Queensland's watch houses for a number of years now. So I should clarify they haven't been in there for a number of years, but since 2019, Queensland has had an issue with overcrowded youth detention centres. The authorities have been using watch houses to detain children and using them essentially as overflow facilities. And children have been kept in watch house cells in some cases. I think the highest amount of days has been 42 days. And there's, as someone who's visited a watch house and seen children who have spent 21 days in a watch house and seen the haunting looks of despair of these children. Some of these children have had hair fall out because of the lack of access to sunlight and vitamin D as a result of these conditions. So the failure of the Act to protect those children, I think, has to be acknowledged. And I think it does go back to the enforceability issue and the access to remedies. And I know that as the Human Rights Commissioner throughout that period, if I had the ability to bring an action in the Supreme Court, I would have done so in 2019. Eventually, when a group of advocates were able to bring Supreme Court proceedings, we saw the Queensland government take legislation to Parliament and rush it through to override the Human Rights Act and to make it lawful to indefinitely detain children in Queensland watch houses. And that remains the law in Queensland, that it is lawful to indefinitely detain children. It's not lawful to indefinitely detain adults. So they're definitely low points. I guess another low point would be, and this was always a risk that I identified at the start of my term, that we would see just lip service paid to the obligations to act compatibly with human rights and to take human rights, to give proper consideration to human rights when making decisions. The staff at the Victorian Human Rights Commission referred to this as decision makers learning the dance steps to derogation. So that's always a risk, that decision makers will just not meaningfully engage with the limitations clause and the proportionality arguments and fully explore the reasonably and less restrictive available options, and just pay lip service to their obligations. And in some cases, I think we have clearly seen that. As I mentioned, obviously, the multiple overrides of youth justice legislation is another low point. And I guess more recently, the summary dismissal of the independent review that Professor Harris Rimmer completed last year and was tabled a few weeks ago by the Attorney General. So there were 73, I think, recommendations that were made in that review, and the government tabled the report, and without engaging in any of the content, just announced that they would not be implementing any of the recommendations, which is very disappointing, because obviously they're with any piece of legislation, there are going to be provisions that require tweaking just for the effective good order of government, and that opportunity, at least for the moment, appears to have been forsaken. So, for what it's worth, my tips for the national campaign: I think it's important that the campaign is very disciplined and coordinated and targeted. In Queensland, as I was involved in the campaign, we were very careful to take, a politically informed approach. So we were careful about how the bill would be perceived by the public politically, and who the backers of it were, so that it wasn't seen as something that was extreme. And that's where organisations like the Law Society become very important. Grassroots stakeholders, I think, are really important in an era where we have fractured mainstream media. It's very difficult, I think, these days, and I'm by no means a communications expert, so I wouldn't pretend to give communications advice. But I do think in the world we live in today, the idea of running a campaign through the mainstream media is fanciful. And I think that's where grassroots stakeholders and grassroots campaigns with directly targeting members of parliament become more and more important. I think in terms of the arguments, the lessons from the Robodebt scandal and the Aged Care and Disability Royal Commissions really demonstrate the potential value of a National Human Rights Act. Just recently I was looking at the Aged Care Act that comes into place on the 1st of July, and whilst it's great that the Act has a statement of rights and purports to position older people at the centre of decision making, it's still lacking the machinery and the enforceability that you would have if you had a National Human Rights Act. It relies on the Aged Care Commission, Safety Commission, Quality and Safety Commission to initiate all the enforcement. So I think there's good reasons that we could show how a National Human Rights Act would improve the protections that are currently in place and will be in place when that Aged Care Act comes in into operation. And finally, one of my staff members asked me today, "What do you mean by riding the Trump pendulum? What does that mean?" And I I think obviously what we've seen globally is a backlash against diversity and inclusion and wokeism, whatever that means. Uh, but I think that there's the pendulum will swing back, and that's why I think being strategic and opportunistic is really important. And I think that there are a lot of uh, good people in the community who are genuinely concerned about human rights and about the excesses of executive government and can see how easy it is for our institutions which uphold our democracy to be dismantled. And so I think in that context, it may well be may well provide, fertile soil for a National Human Rights Act campaign. And just looking at some of the gains that have been made through, I know that a lot of people are very cynical about the United Nations and the influence that it does or doesn't have on domestic policy. But if you look at things like the optional protocol and the Convention Against Torture, which was ratified by the Turnbull government, that really was something that came out of the Universal Periodic Review. So it's these international mechanisms that do actually prompt action on the part of governments. And even though those commitments might be made by those governments and those political leaders at that time without the genuine commitment that you would want and expect for the follow through, and I think Queensland's probably a good example of that as well. Those gains, those incremental gains, are really important, and that's how we ratchet progression towards stronger protections. So I think using all of those international mechanisms is really important. And I'll just note that the Hannah McGlade and Megan Davis recently made their own complaint about children in detention in Australia to the United Nations Human Rights Committee. And whilst we've seen some strong reaction from the state leaders in response to that, I think we can safely say that that does build pressure on governments to act. So I've probably exceeded my time, I'm sorry, but happy to take any questions.
Thank you, Scott. That was an excellent presentation. And I think being able to cover the highs and lows in Queensland and the lessons about the somewhat toothless Human Rights Act we have and the lead up to what got us a Human Rights in Queensland, at least being an opportunity to improve public decision making and the slow build we've had in Queensland towards the culture of human rights. It is unfortunate to hear stories about dance steps to derogation, a term that I might take myself. I quite like that term, as a term and not as a concept. It's important, though, I think, that we take the lesson that you have here in terms of a national focus of targeted and grassroots, and potentially in the same sense as Queensland experienced, where a lack of clear champions isn't a reason that we can't progress to a human rights instrument of some form. And I share the fuzziness in terms of the role that the United Nations has and international law has in Australia, be that good, bad, or something else. But certainly some of the processes internationally that exist should guide us to the conclusion that a Human Rights Act at a federal level is a positive thing, and that we exist as the only Western democratic country that lacks a federal human rights instrument, and particularly one without enforcement mechanisms, should be something that's a clear point for us to continue to put pressure. There is the opportunity for people to ask questions via the Q&A function, the chat function in this team session. But in the interest of time, what I propose to do is introduce our next set of speakers and reserve questions to the end of the event. So if I can invite our colleagues and friends at Civli Liberties Australia, which is an organisation headquartered in Australia's capital city, Canberra, and operates nationally, standing for people's rights, and goes out effectively on the path of everyone having a fair go as a non-political group that is independent of other organisations, and like the Queensland Council for Civil Liberties, does not take funding from government. If I can introduce Chris, Bill and Chris from Civli Liberties Australia to talk about the pathway to a National Human Rights Act.
Thank you, Angus. I'm Chris Klugman. I'm President of Civil Liberties Australia. Before we start, I'd like to acknowledge the Ngunnawal and Ngambri people as traditional custodians in the Canberra region. The campaign for a Federal Human Rights Act must be seen in context. The faith Australians have in government has declined. Surveys like the Scanlon Report and the Edelman Trust Barometer show Australians have lost trust in government and in each other. There has been a decline in social capital, exacerbated by COVID. Government debacles like robo-debt reinforced distrust and alienation. The failure of the Yes campaign in The Voice had very clear impacts. It polarised public opinion into two camps, progressive and reactionary. It made the Labor government acutely aware of the culture wars that progressive social policy opens up, leaving it extremely unwilling to engage in reforms, particularly around election time. We are becoming more insular, relying increasingly on information sources we select to mirror our own worldview. Social media has greatly amplified this trend. Putting our human rights into legislation can start to rectify this situation. The core issue is not new. The UN recognised in 1948, when it formulated the Universal Declaration of Human Rights, that stated that societies were sustainable only if they adopted, protected and promoted human rights. There is nothing new in how governments should respond either. Governments across the world have used human rights acts to filter their legislative decisions and protect rights and liberties. Australia committed to the UN human rights instruments, then walked away from legislating a single National Human Rights Act for many decades. Part of the reason for Australians' declining stock of social capital is that Australians have discovered there is much less protection of their rights than they thought there was. In 2025, we have the opportunity to finally achieve a Human Rights Act for all Australians. We have a clear understanding of Australia's social sustainability that Human Rights Act will be instrumental in fixing. A population that is less and less comfortable with the decline of its rights, as Stuart said, note the example of Trump's actions. 45 years of practice in implementing Human Rights Acts in Australian jurisdictions, and a clear and concise Human Rights Act model endorsed by civil society and the majority of federal parliamentarians in the Parliamentary Joint Committee on Human Rights, and tested by the ACT government. Chris?
Oh, thank you. Thanks, Chris. I'm going to pick up a couple of issues here that Chris raised in that introduction. Just to make a point early though, Queensland has had 2 previous attempts at getting a Human Rights Act up in Queensland. Federally, of course, we've had 11 failed attempts to get a Human Rights Act up since 1948. So the real question is, what's different about 2025 and why we might be a little bit more optimistic about what's going to happen? But before I start, I just wanted to say what's different, why now? Before I start, Chris raised one term called social capital, and I'm going to use that term a lot. So I just want to make very clear what our definition of social capital is. According to the World Bank, social capital is the institutions, the relationships, the attitudes and values that govern interactions among people and contribute to economic social development. Social capital is also the glue that holds these things together, the relationships, trust and a common sense of civic responsibility that make society more than just a collection of individuals. So just bear that definition in mind, because as Chris said, our stock of social capital in Australia is measurably declining. And that decline makes it impossible for governments to generate the acceptance that's needed to make decisions to protect our future best interests. Alone, that these decisions include the three great intergenerational issues of our time: the social wage, recognising our First Nations people, and climate change. Alone among the world's liberal democracies, Australia committed to the UN human rights instruments and then walked away from that single National Human Rights Act implied in the Universal Declaration, and instead we decided to rely on the goodwill of successive governments to muddle through protecting and promoting our rights. And part of the reason for Australia's declining stock of social capital is that Australians are rapidly discovering that there's an awful lot less of this goodwill than we actually thought. Now, Australia's always been a pretty comfortable place for most of the people who live here. Before, say, 2020, rights for most Australians were claims of last resort for minorities like LGBTQIA+ communities or First Nations people or religious groups or asylum seekers and other people who led lives that seemed to be irrelevant to or unimaginable for most of us. We were quite comfortable to have our rights reduced without explanation by government in the name of national security or community safety. We knew that we would not commit the crimes the new laws were aimed at preventing, as successive governments tried to project strength in the face of existential threats like terrorism or being tough on crime and the causes of crime. We never thought that we were going to get caught up in them as a byblow of justice. It was COVID that was the great leveller. When we began to chafe under restrictions that limited our movement without regard to risk, didn't allow us back into the country or forced us to leave relatives to die without family, we asked governments to account for the proportionality of the limits that they imposed on our rights. Our complaints were confronted by an opaque and incoherent morass of legislation with differing interpretations on rights sprinkled through the laws of all 8 jurisdictions. And for the first time, most Australians became aware of what minorities have been telling us all along, that what rights we had depended on our postcode, and that many of the rights we were always told were ours had been lost in a vast maze of frustration, helplessness and political grandstanding. We began to understand that our human rights protections were unfit for efficient and effective decision-making, open to removal by stealth and unreachable when needed. This discovery that Australian governments generally don't have to account to us for their treatment of our rights is accelerating that decline in social capital I mentioned before. We've begun to understand that it's mere privilege that separates comfortable Australians from the tens of thousands of the powerless who can't get remedies for the miseries caused by government's abuse of their rights. This was true from robo-debt through to the Northern Territory intervention to how we as Australians treat asylum seekers, and on to 1,000 decisions made every single day, as been outlined by the Queensland Human Rights Commissioner here, that already that adversely affect the lives of people who cannot afford to fight those decisions. It's also important to note that we are also no longer quite sure who the privilege of being a comfortable Australian now applies to, which drives down our trust in government and each other still further. Australians are a lot less comfortable now. And despite the threat of culture wars driven by toxic populism, the realisation that our comfort as Australians is at risk has proved to be fertile ground for recent political and community conversations on a National Human Rights Act. And Bill will take you quickly through where the campaign has been today. Thanks, Bill.
Okay, I want to run through to save us a bit of time in quick fashion what we've been doing for the past 4 years in terms of the tips that Scott provided for us, covering off many of those, if not all. I want to take you back 4 years and to 2:30 p.m. today, I will update the human rights situation in Australia, which will be good news for all of us. First of all, there are 100 groups. When we talk about grassroots support, there are 100 groups in our collection of organisations who are working under the direction or under the management of the Human Rights Law Centre Reference Group, which includes groups like Amnesty International, Civil Liberties Australia, the Australian Human Rights Commission when it's not in election caretaker mode, national civil society and rights groups, and academics and influencers. Now, CLA in particular, we can speak for, we've been running this campaign for about 5 years. We ourselves, only ourselves, have spoken to or contacted more than 300 individual national groups to seek support, including 50% of progressive federal MPs and all the usual suspects and mainstream Human Rights Act players like Anglicare, the Brotherhood of St Lawrence, Equity Rights Alliance, Integrity Roundtable, Harm Reduction Australia, as well as those people known to have been important to human rights, such as John Stanhope and Helen Watchers. John Stanhope introduced the first act in Australia when he was Chief Minister of the ACT. We've spoken with Rob Hulls, the man behind Victoria, as Scott mentioned, and Peter Russo, of course, from Queensland. We've spoken to Scott McDougall on this 6 months ago. So we're in touch with Sarah Moles, who's running the campaign in South Australia. And we've also tic-tac closely with Rosalind Croucher, Gillian Triggs, who headed the Australian Human Rights Commission in recent years, and George Williams, probably the best known legal academic in this field. We've also spoken to other people that you might be interested to know about. Bob Carr, who was the Premier of New South Wales and was a fierce opponent of human rights, who is now on side, by the way, with a Human Rights Act. I won't go into the details, but he told us privately about 2.5 years ago of his change of heart. We've spoken to Fred Chaney, who was championed it unsuccessfully in Western Australia, Michael Kirby, Simon Longstaff of the Ethics Centre, Frank Brennan, who ran the 2009-10 massive consultation around Australia, Rick Starr, who's was president of the South Australian CCL, and a host of other people. So these are the groups and people behind what's happening. As well as those people we call the usual suspects, we've also made it a point of going out to not usual suspects. For example, the farmers' bodies, the land councils, the Mineral Council of Australia, the Business Council of Australia, the Minderoo Foundation, Harm Reduction Australia, Global Contact Network Australia, to take a sounding among business about what they think of human rights. And in a nutshell, none of them are all worried about a Human Rights Act if Australia goes that way. We always stress the point that's been made that we've got 45 years in experience in Australia in 3 jurisdictions. It's not going to take much for us to do it federally after all that experience. But the very, very key issue, the most important thing, is to elevate a no rights without remedy model of a federal Human Rights Act as recommended by the Joint Parliamentary Committee on Human Rights and implemented by the ACT government into a federal Labor government priority to legislate. The key objective is the tabling of a federal Human Rights Act bill in the first year if a new Labor government is returned, so that in 2025-26 financial year, we will actually have a Human Rights Act on the table. It is important to get it up in the first year of a new parliament, because otherwise it will run into the next round of election campaigning when anything can happen. So there are 3 federal foundations for doing a federal Human Rights Act now. One was the huge report released in 2023 by the Australian Human Rights Commission, which came out firmly in favour of a Human Rights Act. It was called Fair, Free and Equal, and took them 4 years of work to pull together. Behind that was a reference to the Parliamentary Joint Committee on Human Rights, which sat for 14 months and in May last year recommended a Human Rights Act for Australia, among other improvements to the human rights framework in the parliamentary system. And importantly, one of the most important recommendations was for better education for people, which got mentioned, and particularly one of our major tasks or aims, better education for public servants, because they are the nitty-gritty when it comes to actually making a Human Rights Act work. The third pillar of the what is ready in place now to go is the improvement by incorporating a no rights without remedy clause or clauses into the Australian Capital Territories Human Rights Act. We identified very early on that if we were going to demonstrate to the federal government what was needed, we had to have a working model that they could look at and say, okay, we see how it works. And that is no rights without remedy. Now, in shorthand, that means that you've always been able to get a disability issue up before a Human Rights Commission. A discrimination issue up, sorry, before a Human Rights Commission, but you haven't been able to get human rights issues up in a simple, cost-effective and quick way. By enabling that in the Australian Capital Territory, you can get conciliation, and shortly you will be able to go to the local small claims tribunal, ACAT, there's a similar one in each state, QCAT, etc., so that people can get a legal ruling if they need it, if it is needed, if it can't be conciliated in the first place. The ACT will retain its reach to the Supreme Court, which we think is also important and should be in a federal act for federal courts. So this federal campaign, you wonder why perhaps you haven't heard about it during the election campaign. The reason is it's been on hold for the past 3 or 4 months, because the last thing the organisers, the prime organisers, which includes us, wanted was to have any wedge brought up during the campaign about a Human Rights Act between the major parties. We didn't want it to become a casualty. In particular, we did not want anyone to rule it out as an option for the future. So it's been quiet on a Human Rights Act, and we hope we will last a few more days, because we are well and truly set to go the minute a federal Labor government or a Labor Greens Teals government is re-elected. Obviously, if it's a coalition government, we won't be doing this, but we're ready to go as soon as the election is decided. We will be seeking a formal response from the Attorney General Dreyfus on the Australian Human Rights Commission submission under Free and Equal and under the Parliamentary Joint Committee Human Rights reports, which has not been formally replied to in the Parliament. We will be tabling an e-petition in the House of Representatives in May. That's next month. The petition is drafted and ready to go. And if you have our material, you'll see that we've included the draft words in there. We'll be reactivating all the contacts and networks of those 100 organisations that we've gathered over the past 5 years and get them behind the petition and behind the public campaign. And we'll be proactively managing the mainstream media and social media campaign. So it's important just to touch on who supports a National Human Rights Act, is to know that we stand on very solid ground. In 2024, 87% of submissions to the Parliamentary Joint Committee on Human Rights were supportive of a Human Rights Act. Only 4% were against it. Of 335 submissions, 87% supported it. 161 submissions of those to the Parliamentary Joint Committee on Human Rights supported a no rights without remedy, specifically in terms of having somewhere to go if you believe your rights are breached. In 2022, there was a poll run by Amnesty International, and it said 73% of Australians support a Human Rights Act. And that was an interesting finding, because when they were first asked, the people, 49% of people didn't know whether we had one or didn't have one. I suspect that since then their education's gone up, but not nearly as far as we want to take it. Who's behind it in federal political terms, the Labor caucus is behind it. Independent senators like Andrew Wilkie of Tasmania and David Pocock of the ACT are behind it very strongly. 8 out of 10 of the Teals who are in government at the moment are behind it, and the Greens are behind it. So a Labor government or a Labor Greens Teals combination of government would certainly be in our favour if we can get that result after Saturday. So quickly I'll run through just to bring you up to date on where the other jurisdictions in Australia are. The ACT has a full no rights without remedy provisions which are being legislated by the end of next year. Half of those provisions are already legislated. They're having a look at the financial costs of doing the other, of enabling people to go to a tribunal. Those costs, by the way, will be minuscule. We've done the homework and there will be 1 to 2% increase in costing for the tribunal. In Tasmania, several upper house members are planning to table a Human Rights Act draft during this year, and in the near-term future, I hope. There are in New South Wales, there are active groups campaigning, including the New South Wales CCL, Greens, Labor branches, and there's talk of a roadshow by some significant people in the Labor movement in New South Wales. West Australia is an unfortunate case. There's a campaign there led by Australian Lawyers for Human Rights, but it's in the ruling Labor Party platform, but is unlikely to get up, we have to say. The Northern Territory Labor opposition is keen, but they lost the chance before. They were thrown out 6 months ago, and the Country Liberal Party was elected, and they're opposed to it. In Victoria, the 2018 Act reported a no rights without remedy approach, but has taken no action yet. And in Queensland, you know where it's up to. Scott's very ably reported on the up-to-date details on that. I have to tell you, as of 2:30 today, in South Australia, Parliamentary Committee reported to Parliament by tabling its report at 2:30 p.m. that they are urging a Human Rights Act for South Australia. Brand new is that the recommendations say the committee recommends that the government consolidate the various rights and protections afforded to citizens in the many legislative instruments listed in their report into one comprehensive Human Rights Act. They recommend transiting the Equal Opportunities Commission to a Human Rights Commission in South Australia, and they recommend more consultation by government as to the model, which we all assume will be a dialogue model. So we've sent round our notes from this presentation. There's a petition that is there, by the way, if you would like to have a look at that. The other issues that Scott mentioned about the United Nations, there is a universal periodic review going on at the moment where we have to submit by the 7th of June our civil society submission to the United Nations Review of Australia, and that will be lodged and recommends a Human Rights Act be implemented for Australia. So civil society is recommending to the United Nations that we want a Human Rights Act in the Universal Periodic Review. That sort of about sums it all up, but we're happy to answer any questions you might have. Thank you for your time.
Thank you, Chris and Bill. That was a very informative presentation and an excellent summary of where we've been and where we are at now, with a lot of hope on the horizon there for the future of a Human Rights Act at a federal level in this country. I think a profound point that comes out of your presentation, which I think carries very nicely from Scott's presentation, is the requirement to have an enforceability or that there must be remedies attached to the rights in human rights legislation, particularly as it's discussed at the federal level. One observation that I might make in relation to the 11 failed attempts that we've had in Australia at a federal level introducing codified human rights legislation is the unfortunate place that we came from in Australia at the point of our federation. The High Court on a number of occasions has had reason to consider the lack of constitutional protections for human rights in this country. And the example that shines most clearly to me is the rejection that Justice Dawson had that was recently observed by Justice Stewart in Liberty Works in the Commonwealth of Australia, that the decision not to have human rights expressed in our Constitution was conscious and predicated on a view that the founding fathers of this country had faith placed in a democratic process rather than the constitutional guarantees to secure freedoms regarded as fundamental in democratic society. The view being taken that constitutional guarantees would operate as a fetter upon the democratic process, and they didn't consider it necessary to restrict the power of Parliament to regulate liberties. Now, that may well have been true, and questionably, I think, to even put it in that way, at the point that this country federated. Now, over 100 years later, with the social capital changes and the changes in the way that we organise as a society and expect our society operates as between individual members of society and government and as amongst individual members of society, I think the time is right to be having this conversation. And I commend the work that you've done through Civil Liberties Australia in lobbying and putting that together. It is an important aspect of what we do and something that you have done exceptionally well. I have a couple of questions, and if I place this potentially as just a single question to Scott to wrap this up on a nice and technical note. So a question we have, I think, goes to the heart of some of the issues in the dialogue model and maybe exists to amplify these concerns about a lack of enforcement in human rights instruments. The question, framed as rather technical, is what do you think of the recommendation to remove the requirement for Parliament to specifically override the Act? Isn't forcing the Parliament to say what they're doing a benefit?
Yeah, look, there's two ways of looking at it, and I know Rosalind Croucher had a view that even though there was quite a lot of criticism about Queensland's protections, people saying, well, why even have a Human Rights Act if it's so easy to override? But it does at least generate a discussion about human rights, and does at least require the government to purport to set out some exceptional circumstances which would justify the human rights override. The downside, of course, is that by making an override declaration, they effectively remove any opportunity for the courts to have their say in the dialogue model. So there's no opportunity for a law to be taken to the court for the court to consider whether it's compatible with human rights. So yeah, there's two ways of looking at it. And personally, I would trade off the ability of the courts to issue unenforceable declarations of incompatibility against for an enforceable access to direct access to the courts. I think that I would trade that off any day. But yeah, I agree. It's a difficult issue, that one.
Can CLA add something to that? Sorry, can CLA add something to that? Yeah, okay.
Yeah.
Look, very quickly, just to bear in mind that in the ACT, we don't have an override provision, and we haven't had since 2004, and the world hasn't stopped, and the government hasn't fallen over, and we haven't seen murders in the streets or riots. So it's not it's an issue. I think on a broader point, and this point that Scott alluded to in his comments as well, the whole point of the Human Rights Act is for governments to make better decisions. That's the reason we have it. And if you then create overrides on anything the government feels like it needs one on, the benefit of a Human Rights Act in making a government make better decisions is obviated. And so, as I said, for us, and in the campaign that we run, and we agree with Ros Croucher on this particular argument as well, you can have an override for, the four horsemen of the apocalypse. So if you got, death, famine, whatever, but for nothing else. And as I said, for us, making governments think their way through the human rights implications of what they do before they do it is something which is so critical that an override provision applied in the way in which they are applied in Queensland, as I said, just allows decision makers to continue to make bad decisions. And as a result, government decisions are less effective, they are less efficient, and they are less productive as a result. And so, as I said, be careful about the way in which override provisions are looked at, and bear in mind that in the ACT and a lesser extent in Victoria, override provisions are nowhere near as commonly applied as they are in Queensland, it will appear.
I think that's an excellent place for us to wrap up, because I think where we very clearly get to there is the need for enforcement and the ability to access the courts. And although it's back to the proposition of the Founding Fathers having faith in Parliament, potentially that faith is lost with the social capital, and the appropriate thing is to develop this from the states which have introduced human rights, with congratulations that South Australia is now properly on that journey, that a federal act can be the gold standard for each of the states, including mechanisms of enforcement and clearly articulated rights. It's what Australians deserve, and it's what I think you've made very clear Australians expect and have no opposition to. So I look forward to us continuing to watch the development of this over the next couple of years. Hopefully, irrespective of the outcome of this election, human rights very quickly comes onto the table in a proper and complete consultative process that yields a bill that can be supported by our organisations and the Australian people. To our audience, thank you for your time this evening hearing this discussion. Each of the organisations are contactable at respective websites and social media. As has been mentioned a few times through this presentation, each of these organisations are member funded, do not take the support or funding from government or business. We are, so to speak, operating on the smell of an oily rag. If there are donations able and within anyone's means, please contribute to these organisations. At the very least, my ask of all people interested in this space is to keep the conversation going. It's the people that have the conversations with other people that turn tides in the context of rights that we should enjoy, and in the better place that Australia can be taken into the future. So continue a conversation about this. The more discussion there is, the better their outcomes are in the future. Thank you all for your time.
Thank you.
Thank you.